Call the third case on this morning's docket. Case number 115321 and 115322, State of Kansas v. Wesley A. Smith, Jr.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Wesley Smith. May I please have 3 minutes for rebuttal?
3 minutes is granted.
This is a consolidated appeal from two cases that began over 4 years ago. In the first case, Mr. Smith entered a guilty plea to 1 count of refusing to submit to a chemical test, 1 count of driving while habitual violator. Second case, one guilty plea to 1 count of refusing to submit to a chemical test, and 1 count of DUI. In both cases, the pleas were entered, it's my understanding, with the parties understanding that Mr. Smith would be able to appeal the district court's previous denial of his motion to dismiss the chemical refusal test based on that it was unconstitutional. Mr. Smith filed his briefs. The state moved to both consolidate and stay pending Birchfield. Fast forward till September of 2016 or August of 2017. In the interim, Birchfield came down, Rice 1 came down, Birchfield comes down, then Rice 2 comes down. The case in August of 2017, the stay is lifted, and the state moved to dismiss, arguing for the first time that Mr. Smith could not challenge the constitutionality of the statute because he had entered a plea. He was in order to do so, he would have to file a motion to withdraw his pleas. That motion was denied. The state filed its brief. We filed a reply brief where we, for the first time, were able to address the state's issue. The Court of Appeals ultimately affirmed the case, adopting the state's arguments, and we are now here following this court's grant of our petition for review. Start off with the fact that...
Counselor, are the motions to dismiss on the constitutional ground in the record on appeal?
The hearings are, I know that.
Okay.
In both cases.
Okay.
I didn't look at volume 1. I know that, and I specifically know that in the first case, 14 CR 1298, at the end of the sentencing, the district court said, when he was informed of his rights to appeal, said you may want to join all those other constitutional challenges when you file your appeal. So I'm almost positive they are.
Okay.
But I know the hearings are on them. So it's clear that he did challenge them.
No, go ahead.
I was just going to say that no one disputes that currently Mr. Smith is convicted of 2 convictions for things that are not crimes in Kansas because the statute was unconstitutional.
But he pled to those convictions, and I looked back over the plea colloquy, I looked back over the written plea agreement, and in every one of those documents, the written plea agreements in both cases, plea colloquy in both cases, he waives his right to an appeal. Is there any dispute about that? And even though he brought up the constitutionality of the hearing and was denied, he later waived that right to entered into plea negotiations, accepted the benefit of the bargain, and waived his right to an appeal.
I'm going to be honest with the court. Actually, I don't have an exact recollection of the plea deals themselves. I do know that
there was a bargain for exchange.
There certainly was.
There was in both cases. Some counts were dismissed, pled. Some presumptions on sentencings were agreed to, and accepted the benefit of the bargain. And a part of that was a waiver of a right to an appeal of an issue that he raised. I mean, isn't that what happened? I mean, that's what happened.
Actually, I'll disagree with you. There was never any explicit mention of the appeal he raised. And I'm trying
it says I'm waiving my right to an appeal.
My recollection was that he never specifically mentioned the constitutionality of that. And I think if this court's jurisprudence on waivers of rights to appeal is they are very strictly construed.
And I guess my point is we get cases all the time that preserves issues of constitutionality of the search, of suppression, and they're done by either stipulated facts in a trial. It's basically an extended plea, really, in terms of a trial to the court on stipulated facts, so those issues can be preserved. That didn't occur here. And here, this is a typical plea in which there was a bargain for exchange, and one of those was the waiver of a right to an appeal, which happens in every case, typically every plea.
I'm going to state that I think it's clear from, if you look at this case, actually, apparently it's now fortuitous that there was an Ortiz issue in this case, and his defense counsel, who is now a prosecutor down in Sedgwick County, explicitly stated in the letter to this office, to our office, which was attached to that motion to reinstate appeals, Appendix D, that he fully intended the whole point of everything was for him to appeal that. I'm going to be totally honest. I'm going to guess that particular trial counsel didn't know. I mean, I can tell you, it's obvious to me that the proper procedure.
It was the intent of trial counsel, who's now one of your colleagues, and
One of Mr. Sherwood's colleagues.
But explain that to me again. It was his intent to preserve this.
Yes.
Yeah, and that's not stated anywhere that I could find.
If you look at the motion to reinstate appeal, attachment D, it is a letter dated March to Christina Curls, dated March 2016. March 28, 2016, but it's attached to the motion to reinstate appeal that is part of this court's file in this case.
How can we consider that? Is it really part of the appellate record?
This court can always take judicial notice of its own files.
Of something that you put in the files?
No one challenged it. Everyone agreed to it, and
It just recites facts that I'm not sure we can or should consider because those facts weren't there in the record.
I think I want to bring it back actually. I feel like we're getting really far afield on this. The bottom line is this is a jurisdictional question, and you can't waive jurisdiction. The question here, and I guess I'll have to stick, we know that this was a facially unconstitutional statute. We all can agree. This court in Rice, I remember that case, this court said it's facially unconstitutional. Griffith v. Kentucky says you get the benefit of that on a direct appeal. This is a direct appeal. This court can question jurisdiction on appeal. And indeed, in so doing, it also has, I think, a duty to question whether the district court had jurisdiction on this appeal. Jurisdiction is the power to hear a case.
Can we turn your attention to KSA 223602?
Sure. A specifically?
I believe so.
That is, I think if you look to, I cite in the petition, and I think in my reply brief, I can't remember if it was pending still or not, but Class v. U.S., the United States Supreme Court gives us a good example there.
How does Class square with this specific statute in Kansas, which Class did not involve?
I'm getting there.
All right.
In the Class was a question of whether or not Mr. Class could appeal what he believed was a facially unconstitutional statute following a guilty plea. In the federal system, you can enter a conditional plea, unlike in Kansas. And if you enter a conditional plea, then the remedy, I believe, is you get to withdraw your plea. So that's kind of analogous in that there is a means of doing that, of appealing a particular issue from a guilty plea. The federal system is like Kansas, where typically a guilty plea waives everything. Said there is this particular.
It's an implied waiver.
In Kansas, it's specific to statute. And the federal law doesn't have an equivalent of 223602. And it's the case law that's developed that says it's an implied waiver, it's a waiver. Here,
Correct.
it's specific to statute.
Correct. And I'm getting there.
All right.
But what Class said was, even though we have this method as a conditional plea, it's not the only method. Nothing ever said this is the only way you can get into appellate court. And they said because it's not the exclusive method, you can't. KSA 223602 never says it's the exclusive method.
Don't we have case law that says that jurisdiction is exclusively afforded by statute, appellate jurisdiction.
We have case law that says that, but if we
Is
look,
it wrong? Is that case law wrong? Is there some other way that a party can get appellate jurisdiction other than a statute?
I think this court has recognized, I know this court has recognized implicit statutory authority. Specifically, the cases the states rely on, Hall, if you look back to its lineage, it goes from Hall to Williams, Thorpe, back to Solomon. And in Solomon, one of the questions was whether there was jurisdiction at all on a motion to withdraw plea. Now, if you look at 3210D, there's nothing in there that says you have a right to appeal the denial of a motion to withdraw a guilty plea. This court found there's an implicit right to do so. So things are not, although we say typically, yes, the right to appeal is statutory, this court has gone beyond statutes in and of themselves. And in this case in particular, even if, well, I would say one of the points I wanted to make is the United States Supreme Court says if there is a substantive constitutional problem, the courts just can't ignore it. They can't say, oh, you don't have a procedural mechanism. That's Montgomery v. Louisiana. Now, we're saying, however, there also is a means via the motion to correct a legal sentence statute.
Well, you can go under 1507, can't you?
That's another means. These
So
are
how does-
all
how does
different
class-
means.
So how does class apply then? When the Kansas legislature has said, particularly in this statute, 1507.
It references that, but it
Yes.
doesn't say that's the only means. It never says it's the only means. And in fact, if we're talking about jurisdiction, our motion to correct a legal sentence statute explicitly says jurisdiction is one of the things that you can raise. So, and whether or not a sentence conforms to statute. Both of those things apply in this case.
Well,
He was sentenced to
we've said you can't utilize the motion to correct statute to attack an underlying conviction. We've been
can't
pretty
be sentenced.
consistent about that.
We know that. We know, though, that if you can get into court with it. So we can get here by the motion to correct a legal sentence, we're not challenging the constitutionality at this point because the constitutionality is already decided. We're entitled to that on direct appeal, to that under Griffith v. Kentucky. We can challenge his sentence, however.
Was the sentence illegal when it was pronounced?
It does, under this court's recent case law, unless you're raising a collateral motion to correct a legal sentence, you still get it if you're on direct appeal. It has to happen as of the legality at the date of sentencing is something that applies if you're making a collateral challenge to a motion to correct a legal sentence. This is still a direct appeal, and you can't ignore Griffith v. Kentucky that says if a case is on direct appeal, you're entitled the application of a new rule is applied to all.
That's a substantive rule, not a procedural one.
This is certainly a substantive rule of a statute.
Well, but we've
being
got
facially
jurisdiction in
unconstitutional.
play. That jurisdiction's procedural, right? It's not substantive. It doesn't go substantively to your claim for relief. It just goes to whether or not you get in the courthouse door.
We're in the door already because we can challenge.
Well, the Court of Appeals said you weren't.
Right? Yeah.
That's what's before us.
If we're going to talk, when you talk of jurisdiction, you have to get into a court to even argue jurisdiction. So we're into if in the district court you have to get in there, even though we know from Dunn jurisdiction there has to be a criminal statute for you to challenge to be brought into court. You have to be brought in under a criminal statute. We know that from Dunn. That's the one exception. You no longer have to have all the elements there, but you have to allege a crime. There was no crime here. It's an unconstitutional statute. It's a nullity. It's facially unconstitutional. So therefore, there was never a power, and that's our point. Jurisdiction can be raised at any time. And there simply was no jurisdiction for the district court to take his plea, convict him, and sentence him. Because there is no statute. 8-1025 is a nullity as a facially unconstitutional statute.
I want to go back to 223602 and ask what in that statute indicates to you that you do not have to proceed under just 60-1507 to raise this issue.
There's no explicit language, and the rights of the criminal defendant are broadly construed on appeal, the appellate rights.
Well, it does say no appeal shall be taken by the defendant from a judgment of conviction before a district judge upon a plea of guilty, which I understand we have here, except that jurisdictional grounds going to the legality of the proceedings may be raised by the defendant as provided in case A 60-1507. Okay. So your position is that language does not limit. Is that
No,
right?
that if there are other mechanisms. I mean, clearly if that was limiting, then there'd be no way to get at a motion to withdraw plea. Because you're appealing your conviction there.
No, you're appealing the denial of the motion. You're not appealing the conviction at that point.
The final
On the motion to withdraw?
I'm sorry, the final judgment, though, in a criminal case is your conviction and sentence. So you're appealing from the conviction. That's the language we use when we talk about what you can appeal from. You can't have an interlocutory appeal for a defendant in a criminal case.
Do we have any further questions? We've taken a lot of your time with our questions. Do you need 30 seconds or so to wrap up, or do you want to wait till rebuttal?
I'll go ahead and wait until rebuttal. Thank you.
Thank you, counsel.
May it please the court, Assistant District Attorney Boyd Isherwood on behalf of the state of Kansas. And I guess before I jump into this and get going, I'm not quite sure where to start, because it looked like we, at one hand, were talking about a 1507, then we switched into the conviction, and then we switched to sentencing. So just with respect to the 1507 aspect of what was being raised, Mr. Dunn did indicate in one of his briefs, be it the petition for review or something, that there was this attachment D that raised something with respect to a motion to reinstitute an appeal or something. However, that attachment, as far as I can tell, was never attached to the brief. So I don't know. Justice Stiegel indicated that how are you going to get it in by attaching it? Well, you certainly aren't going to get it in by not attaching it, but indicating that you did. I never saw it. It's not in the brief that I received, and it's not in the brief that's on the court's website. The next thing with respect to the 1507 that was interesting to me, and I do believe this is in the record, is the ruling. Keep in mind there were two separate cases here that were consolidated. So it was a ruling in 14 CR 1298. It's the ruling on the motion to dismiss based on the constitutionality, and the district court's ruling says, per the agreement of the parties via email correspondence with this court, the court rules without appearances, without oral argument, and without a hearing, the motion is denied. So the plot thickens on the 1507 aspect of it. But this highlights exactly why we shouldn't be doing this here, and it highlights that even though there is another mechanism to make this argument in the 1507, as Your Honor pointed out, it's at the district court that it happens, because there needs to be some discussion about what happened. We can't do that here. I'm not going to testify on behalf of anybody who, as a matter of fact, is no longer in our office. I'm not going to testify on behalf of anybody about what happened. The record apparently is not clear about what happened. As far as Mr. Dunn is correct, it does appear that the pro se notice of appeal in both, and at least one of the notices of appeal by the attorney in another case, in the other case, do reference preserving this ruling. As an officer of court, I'll add that. But the bottom line is, when you look at the plea hearings themselves, when you look at the actual pleas, they do indicate, at least the plea, I don't know if the plea hearing expressly says it, but the plea itself indicates that he's waiving his right to appeal. It's spelled out. There's no question. It's there. All of Mr. Dunn's arguments in his briefs, be it the reply briefs, the petition for review, supplemental petition for reviews, whatever it is, all of the arguments that he makes about being able to, that there's this Supreme Court case, the United States Supreme Court case, or the other one that allows him to question jurisdiction, he's not wrong. The problem is he's making his argument to the wrong court. I'm not suggesting that he can't question jurisdiction under the particular factual scenario he finds himself represented with. He just needs to do it in district court, and either a 1507 or a motion to withdraw plea. That's what the statutes in this state say. It just can't happen here. And of course, what we're talking around is trying to do exactly what is expressly forbidden here to get his convictions overturned. He then doesn't have to face the possibility of the charges that were dismissed if he files a motion to withdraw a plea. And this is his choice, something that I'm sure you understand, but I'll just say it that way. Something you need to understand is this is his choice. It was his choice to bring it in this court. It was his choice not to bring it at district court as a motion to withdraw plea, arguing, hey, guess what? That statute I was convicted under indicates now there's case law that indicates it was unconstitutional. Now what? But he didn't do that. He chose to bring it here when he knew that he couldn't. This brings up issues of whether the state would be able to make arguments with respect to frustration of the purpose. If he brings a motion to withdraw a plea, all of these things are being avoided by trying to force this into your hands. That is precisely what the Court of Appeals saw and noted there was a way to do this by doing the stipulated facts, but it wasn't done. Now, whether counsel handling the case for the defendant was unaware of that, didn't care, I don't have any idea. Apparently there's some statement that has been made, of which I'm not privy, indicating that there were attempts to preserve this. But that's relevant. But the question is, what is it relevant to? It's relevant to a hearing in district court. There's nothing that opposing counsel has expressed to this court that should lead you to conclude, oh, it's 2019, almost 2020, and we've had this whole thing about not having jurisdiction to attack your conviction on direct appeal wrong all of this time. It's not there. It doesn't exist. It's not wrong. There's a statute.
What does as provided in 60-1507 mean in 22-3602? Is it broad? Is it just specific to 1507s? What's your best answer?
The statute clearly says that. I cited it in my brief.
Right.
I don't think that the Court of Appeals gave it any treatment whatsoever. I wasn't aware that the 1507 inference was there. I didn't think it was at one time. Maybe it changed. I could be wrong. But I don't know. Suppose we'll find out. Should Mr. Dunn's client choose to bring it? But it's also important for what it doesn't mean. And I don't know how you twist that to mean, oh, and by the way, you can attack your conviction on direct appeal.
Right.
In an appellate court. That's what it doesn't mean. I think that's important. What it does mean, maybe this case will flesh it out when he avails himself of the relief that is available.
Is 1507 still available to him since he's completed his time?
He would have to have been under sentence, but again, his choice. Mm-hmm. And perhaps there's yet another exception that can be made on 1507's out of time. I was out of time because the attorney handling my appeal didn't. I don't know.
Yeah.
I don't know.
Okay.
Could be. But you're correct. The law indicates you need to file it while under sentence. And it's my understanding, although I can't personally verify, but that he has finished his sentence. So he'd have a hurdle there, I suppose.
Does he have any other possible avenue of relief besides 1507 if it turns out that doesn't work for him?
Motion to withdraw plea. Absolutely. Where it should be, but could have been all along.
Do you have any further presentation?
No, Your Honor.
Do we have any more questions? All right, thank you, counsel.
If I might just take a second, I realize this is the last time that we'll be presiding over the court, and I just wanted to congratulate you on your retirement and indicate that it's been a joy to appear in front of you. I'll say so many times and leave it at that.
Thank you, counsel.
Thank you.
Very kind.
As I have said so many times, at my own peril. First of all, I'm not sure Yes, the attachment D was referenced in the petition for review and for some reason didn't get attached to that. However, Mr. Isherwood was specifically served on April 20, 2016 with the motion to reinstate appeal. It did not even generically go to his office. It specifically went to Mr. Isherwood. So if there was a problem down in Wichita with him getting it, I'm not sure what that is. This comes down to really, can a guilty plea create jurisdiction to convict and imprison someone for an unconstitutional crime? The United States Supreme Court doesn't allow it under federal law. This court shouldn't allow it under Kansas law.
So what happens here? The benefit of the plea is just what happens with the state's concern about that arises from if the convictions are found not to be found to be unconstitutional. He still gets the benefit of the bargain.
I think the state has what I might say less than clean hands, knowing full well and good, particularly in Sedgwick County at this point in time, that relief had been granted to several criminal defendants, and that there was a split in the district courts in Sedgwick County on the constitutionality. This wasn't something that came out of the blue to the state. And I would point this court to Class itself. In Class, Mr. Class got a plea deal. There were things dismissed, he got a deal. If it didn't matter to the United States Supreme Court. The bottom line is, if you can't be hailed into court on a particular crime, that conviction can't stand.
To that point, if we disagree with your statutory arguments and we do not see a grant of jurisdiction in it, implicit or otherwise, in any of our statutes, I understand you to say that is a problem, that you still get into court through some other avenue.
I think that Montgomery v. Louisiana said that when Louisiana was had set up to where the defendant in that case could not,
So what's that avenue?
No means.
What specifically, what body of law are you relying on to get jurisdiction?
I believe that's a due process issue, cutting them out.
So the legislature does not have the power to divest the court of jurisdiction
To divest,
in a criminal case.
if
That's your argument.
yeah, I think you can't in the case of a substantive constitutional challenge. A procedural challenge, yes, that's different. But you can't. I mean, this court said.
So even if the legislator just wrote a statute that said there shall be no appeal,
Our Constitution.
we would have to take the appeal anyway because we would be obligated to do so pursuant to due process.
I think if we look to Article 3 of our Constitution, vesting judicial authority, I think somehow it would have to be.
There's some sort of inherent power, whether it arises under the Due Process Clause or under Article 3
Yeah,
of the
I
state
think
constitution.
you can't just take everything away. I mean,
So that means that our case law that says we have jurisdiction pursuant to statutory law is wrong.
no, I think this is a very
least
limited
incomplete.
circumstance. In the circumstance of when someone has, you can't for a conviction under a facially unconstitutional statute. I mean, it makes no sense that someone, if you couldn't have ever been brought into court, which we've said that's a requirement to come into court, is there has to be a crime. All crimes in Kansas are statutory. We don't have common law crimes. So if there is no criminal statute, you can't be prosecuted in Kansas for it. And that's exactly what happened here. There is no criminal statute. It was an unconstitutional, facially unconstitutional, not as applied. As applied would be different because you have jurisdiction when it's an as applied situation. It's just a factual question of whether or not it applied in that situation. But this is facial. The statute is gone. The statute that he was sentenced under, gone. No sentencing thing. If you look at Collins and Boswell, in those cases with upward departures, the court was still able to reach those, and there was something that supposedly divested jurisdiction there when the statute said those were the result of plea agreements, and those cases were pleas too. This is a plea too. You can't divest the court of jurisdiction in that situation.
Do we have any further questions? Counsel, what are you asking us to do?
I am asking the court to reverse the Court of Appeals and vacate Mr. Smith's convictions for refusing to submit to a chemical test in both cases. And
Thank you, counsel.
one quick thing, as promised on Wednesday, I do want to congratulate Chief Justice Nuss on your retirement. In the 17 years I've been practicing before you, I have not always had my way, but I've certainly enjoyed it and been very respectful and certainly enjoyed that. And particularly as your time, have enjoyed it as you since 2010 as Chief Justice. So thank you and good luck.
Thank you, counsel. Very kind. Thank you both for your very generous comments and your arguments this morning. Court will take this matter under advisement.